Welcome to Case by Case. This is a podcast brought to you by Calum and Luke Zadkovich of Zyla Floyd Zadkovich. How are you doing, Calum?
I'm good, thank you, Luke. How are you?
Very good. I'm excited to talk about shipbuilding contracts and in particular guarantees that are put in place to back shipbuilding deals.
And this one is truly hot off the press. It's last Friday was the date of this judgment was handed down. So this is very fresh new law.
Well, this is, I think, 2 days afterwards. So,
well, exactly.
Couldn't get much more prompt than that. It's a decision coming out of the Court of Appeal in England and Wales. The names of the parties involved. The appellant is Shanghai Shipyard Co Limited, and the respondent on this appeal is Rainwood International Investment Group Company Limited. The hearing was relatively recent as well, on the 14th of July, and a speedy turnaround with a judgment delivered on the 23rd of July 2021. The court comprised of Sir Geoffrey Voss, Master of the Rolls, Lord Justice Baker, and Lord Justice Popplewell. Calum, would you like to open us up with some facts for this one?
Yeah, let's talk through kind of what happened and why they got to the Court of Appeal. So this was a shipbuilding contract originally between Shanghai Shipyard Co., who were the appellant, and Rainwood, who were a financing party effectively brought into this deal via a company called Opus Offshore Limited. And the intention, as we see often in whether it's shipbuilding or long-term charter parties, which are entered into in contemplation of a new build, you often see that the original kind of buyer or the original charterer enters into the agreement, but it's known between the parties that they're going to be substituted out and they're going to be swapped in for the actual ship-owning SPV. And that was the case here. By an addendum further down the track, the buyer was swapped to a company called Opus Tiger One, which was a single ship entity created for the purpose of holding this vessel as an asset. And it
became a one ship company from a no ship company.
Exactly.
As the court described it.
Yeah, it started off as a no ship company, and that is exactly why we had the issues around the guarantee for the final payment. The way that the payments were structured for this shipbuilding contract was that the final payment was an extremely large one. It was a $200 million shipbuilding contract, and there was a final payment on delivery of $170 million. And that was guaranteed. The final installment was guaranteed by Rainwood, who were originally the buyer. They then became the kind of final payment guarantor. And the question before the court was whether that guarantee was a on-demand guarantee, in that it was payable on receipt of a written demand, or whether it was a guarantee which was entered into as surety, and it was only payable in the case that there were obligations owed by the party being guaranteed. And that's essentially what the court was looking at. And the High Court had found that it was the latter. It was a surety guarantee. And the Court of Appeal found the opposite. They allowed the appeal, finding that it was a on-demand guarantee. Yeah.
And it might be helpful just to briefly touch on what are the differences there in an easy to understand way. A surety guarantee, or a see to it guarantee, is when the guarantor pays out in the event that the underlying debtor does not honour its obligations, whether during the contract or on a final judgment or award, and then the guarantor steps in to see to it that the debtor makes good on its obligations. That's a surety guarantee. It's almost after the event, if you like. And a demand guarantee is, as the name suggests, it's a guarantee that pays out on demand. It doesn't require a showing of the underlying liability of the debtor, or indeed established liability of the debtor, for the demand guarantee to have to pay out. And there'll be some requirements on the type of demand and when the demand can be issued, but the basic premise is that the money is paid out by the guarantor on demand. And one may ask, why, or what is the rationale between these two guarantees? Why is there a difference for them? And it really comes down to cash flow, because in a demand guarantee situation, the guarantor is having to pay out at an earlier stage, and the beneficiary is being put in the funds. That's not to say that there might not ultimately have to be some recredit by the beneficiary back to the guarantor, depending on the underlying liability of the debtor and the nature of the guarantee. But from a cash flow perspective, the money gets paid over out of the guarantor's pocket into the beneficiary's pocket. And then, whatever issues there are remaining can play out in due course. And that's really the fundamental difference here. Are we looking at a guarantee that is, see to it after the event, or is it upfront demand and payment has to be made at that stage? And in this decision, as you say, Calum, that was really the threshold issue. That was the primary issue on appeal. There is also a secondary issue as to whether there was a proviso on the demand guarantee, which we'll come on to separately and deal with after looking at the first issue.
Yeah, and I was interested when Popplewell was going through the different types of guarantees, talking about a demand guarantee. And as you've said, there's very likely a requirement that the parties may have to further down the road if liability is not established, or I suppose I should say if liability is established not to exist, then there might be some accounting back from the beneficiary to the guarantor. But I was interested to see that that's not actually settled law. It didn't come up here, and I wonder if it's just so obvious that it's never been argued.
It was Barry QC who was on for.
Yeah,
I think he conceded the point, and so it wasn't actually argued before him. But there was almost like a floating question mark in the judgment, wasn't it? It was just kind of left hanging there.
Yeah, exactly.
But it's not a settled point.
And I like the way he put it, which is, is this pay now and argue later? Or is it pay now and never have to argue? And it seems to me very unlikely that it's the latter, but it's interesting that the point's not kind of crystallized under English law.
Yeah, very interesting. And so I think one of the key points to kind of take away from this case in seeking to determine whether a guarantee is a surety guarantee or a demand guarantee is to look at the entire guarantee and look at it, take it as a whole. And rather than picking some words out of the guarantee and saying, oh, this is like a prior case which was held to be a surety guarantee, or here's some other words that suggest it was a demand guarantee, the court kind of steered the parties away from that and really was laying down the principle that you need to take it as a whole and look at how it all works together, as well as the commercial context.
I think that's really true, and it's an interesting point of contractual interpretation that comes from this decision, where there's definitely a tendency, certainly when you're looking through case law, to find a decision that supports your client, to see words that match the words in your contract and go, this case says what I need it to say. If this word's inserted here, then that means this. And this case reiterates that actually it's a broader exercise interpreting a contract than simply saying these words mean these things. You have, sometimes that can be helpful. There are certainly some contractual clauses that have settled effect at law, and you can't overlook those clauses. But at the same time, pointing to individual words that may have meant the same thing in one case, they don't necessarily mean the same thing in the context of the contract as a whole. And I thought that they did well to kind of explain that in this case before then going on to say, okay, these are the factors that we see in this guarantee as making it one which is more on demand in nature than a see to it or surety guarantee.
Yeah, there was a line that I really liked. I just like the phraseology of this, and I'll read it out. I would associate myself with the concern expressed by Lord Justice Longmore in Wuhan. Putting aside the reference to Wuhan and recent events, that line, I would associate myself with the concern. I think that's just a brilliant line.
Yeah, it's not, I like when you come across these lines, and it's always good fun to try and put them into ordinary conversation with friends and family.
Yeah. I would associate myself with the concern expressed by my 4-year-old son, who doesn't want to play with the toys anymore. Yeah.
It's no longer time to play with the tractor, and I would associate myself with that concern.
Well, the concern that he was associating himself with was analysing over 20 authorities in order to resolve the issue. And I think that's this point, isn't it? It's a useful point when speaking to like law students or juniors coming out of law school and looking at contract construction and how to interpret contracts. That yes, we have the common law and it's built on cases, and you have to look at cases to establish precedents and find the ratios and all of that. But this kind of dissection of a clause to pull out a few words here and then, apply how other cases have dealt with those particular words to extrapolate meaning. It's a little fraught with danger. And the other point on this is that the court took the submissions that were made by the guarantor on behalf of the guarantor in trying to almost start the construction question from the vantage point of who was the party issuing the guarantee, which I thought was an unusual type of argument when I saw it there. And that was to say that, well, the guarantor is a financial institution, or the guarantor is a bank, or the guarantor is an individual, and they are more likely to issue sureties or demand guarantees. And then from there, we start to conduct the contractual interpretation. And that does not seem commercial. And indeed, I agree with the court respectfully in where it said that it would lead to uncommercial results.
I think that's got to be right. It did seem to me a strange place to start, and maybe it's been done in previous cases, and maybe there is some authority to, or maybe there was prior to this decision some authority to start the analysis in that way. But it seems at odds with the way that a contract would normally be analysed under English law, which is to look at the contract.
Yeah, exactly. So, moving on to this particular case, would you like to perhaps run through some of the key features of this clause? I think I've jotted down a few as well myself.
Yeah.
And why the court went the way that it did on this one.
Yeah, I think that's a good idea. So I'm going to go back to the guarantee itself.
Yeah.
And at first you have a couple of clauses essentially saying who's doing the guaranteeing and what's being guaranteed. And then you have clause 3, which says, we irrevocably, absolutely, and unconditionally, all in capital letters, guarantee as primary obligor and not merely as surety the due and punctual payment by the owner of interest on the final instalment guaranteed hereunder at the rate of 5% per annum from and including the first date and after the default until the date of full payment by us of such an amount guaranteed hereunder. And the second clause that I thought was interesting, very interesting actually. This was the clause that I kind of struggled with the most when I was reading the guarantee at first blush, reading through the judgment, is clause 4. And it says, in the event that the owner fails to punctually pay the final instalment guaranteed hereunder in accordance with the contract, or the owner fails to pay any interest thereon, and any such default continues for a period of 15 days, then, upon receipt by us of your first written demand, we shall immediately pay to you or your assignee all unpaid final instalment, together with the interest as specified in paragraph 3, hereof without requesting you to take any or further action, procedure or step against the owner or with respect to any other security in which you may hold. any other security which you may hold. It then goes on to say, in the event that there existed a dispute between the owner and the builder as to whether the owner is liable to pay the builder the final installment, and the builder is entitled to claim the final installment from the owner, and such dispute is submitted either by the owner or by you for arbitration in accordance with clause 17 of the contract, we shall be entitled to withhold and defer payment until the arbitration is published. We shall not be obligated to make any payment to you unless the arbitration award orders the owner to pay the final installment. If the owner fails to honour the award, then we shall pay you to the extent the arbitration award orders. And that to me was an interesting one, because the top half is very on-demand. It reads very much as an on-demand guarantee. The bottom half, at first blush, read much more as a see-to-it guarantee to me.
Yeah. Let's just break that down a little bit. So the top half, where you're talking about clause 3, sounding much more like a demand guarantee. The words that are kind of triggering that, as Lord Justice Popperwell noted, absolutely and unconditionally guarantee as primary obligor, although those words are neutral, but these are key words, and not merely as surety. So there's an express attempt here by the drafters of this guarantee to say this is something more than a surety guarantee.
Yeah, and that's repeated. Not only I read out the part which deals with the interest, but that's also that same wording, irrevocably, absolutely, and unconditionally, and not merely as surety, is also repeated in the section where it deals with the full final payment installment.
Yeah, and I just don't see how the guarantor could convincingly argue that the words "and not merely as surety" was simply surplus. As the court said, they really goes to the heart of the obligation that's being guaranteed here. And then you have this wording that comes through in the second. So the second part of this, so clause 4, which you read out, which we said has more features, if you like, of a surety demand. Bound up in there, though, are still words that go to suggesting this is a demand guarantee. And those are the words where it says, upon receipt by us of your first written demand. That's hallmark demand guarantee language. We shall immediately pay to you or your assignee all unpaid final installment. So this concept of immediate payment, again, that's not really something that's appropriate for a surety guarantee. So yes, the clause does go on to have this structure around, a dispute and getting an arbitration award and all of that. But when you look at the key words, the critical language in this, and this is really what the court clung to, those key words that I've just highlighted in those two clauses are what the judgment was founded on, to say that this was a demand guarantee, not a surety guarantee.
Yeah, and when I say the two parts, the first being more akin to a demand guarantee and the second being more akin to a surety guarantee, I kind of include the top of clause 4 in the demand guarantee wording, as you say, upon receipt by us of your first written demand, and we shall immediately pay to you. That's clearly.
I see what you're saying. Yeah. When you say the top half, you mean the first sentence of clause 4 along with clause 3 is the top half.
Exactly.
Yeah.
But then you have to square the second section that says, well, if there's a dispute and the dispute's gone to arbitration, then actually we'll play out the whole question of whether or not there is an obligation to pay.
Mm-hmm. Mm-hmm.
And that, I think, is a slightly difficult carve out to reconcile, and I think the court got it right here to say that essentially, that second part where it talks about if the dispute's been put into arbitration, then we wait and see what happens in the arbitration, and we'll pay you what's actually owed following the arbitration. The court essentially said the guarantee is a on-demand guarantee. It's written as an on-demand guarantee, and it acts as an on-demand guarantee, but there's a carve-out if there is an arbitration ongoing. But the arbitration has to be ongoing at the time that the demand is made, because that's what the carve out says. So they looked at it kind of in quite a literal way, this carve out, and they said, in the event that there existed a dispute and the dispute is submitted by the owner or you to arbitration, then we can withhold and defer payment until the arbitration award is published. What they didn't say is what happens if there's a dispute but arbitration has not been commenced. And the court effectively said, if there's a dispute about the liability of the buyer to pay what is due under the shipbuilding contract and what you've guaranteed under the shipbuilding contract, then the buyer needs to put that into arbitration pretty quickly. They need to move fast, put it into arbitration, put their money where their mouth is, as Papa well said, and move it into arbitration. Otherwise, this guarantee exists as a non-demand guarantee.
Yeah, exactly. It was quite a straightforward finding on that second question, that for the proviso to the demand to be triggered, there must be both a dispute and commencement of arbitration prior to a valid demand being made. And if that has not occurred before the demand is made, then the builder has an accrued right to payment under the guarantee. And that is a right to payment immediately upon a valid demand.
And I think it's quite difficult. I think that's the hardest part of interpreting this guarantee, is it's potentially quite difficult for the buyer and the guarantor to put this question to arbitration before the demand comes under this guarantee. So effectively, it struck me as being unlikely that proviso would ever have actually been used, because it would have required the buyer. I think that the buyer got 10 days notice of the ship being ready for delivery, following which they had 15 days to kind of raise a complaint before the payment was due. So there was about a 25-day period for them to, understand the condition of the vessel, to take issue with it, to communicate their issues with the status of the vessel to the builder, and then to commence arbitration. That strikes me as a very tight timetable for, becoming aware of an issue through to commencing arbitration.
Yeah. The other construction point perhaps to mention here is that before the court focused on the critical language, they also went through a number of words in the provisions that were neutral. So they kind of went through and said, well, the fact that Rain would be the buyer for up to a year before the SPV was created, that was neutral. The primary obligor language, that's relatively neutral because it could be used in a surety guarantee as well. And other things like words like due and punctual payment and payable and punctually. These words, the parties tried to use them to show that this is more a surety or a demand. But of course, they're all relatively neutral clauses. And then went on to say, well, what is the critical language here? What is really at the heart of the guarantee? And that's where those words that we've already talked about, they were instructive of what this guarantee is.
An interesting point, an interesting question, I suppose, is we see a number of guarantees where it's not clear on their face whether they're on demand or whether they are kind of see-to-it guarantees, surety guarantees. And I suppose it's not terribly difficult to draft language making it clear which one it is. The nature of the guarantee is not difficult to draft if you're starting from a position as the drafts person. It's not difficult to create the guarantee to make it very clear what sort of guarantee it is. And I wonder if these guarantees that get through, this is a $200 million contract. You'd expect it to have been drafted, heavily negotiated and drafted on both sides with good lawyers. So it's not a kind of accident that this ambiguity comes through. And I wonder if it's just that each side is trying to kind of reduce their obligations a little bit one way, a little bit the other way, and it's almost easier than being upfront about the nature of the guarantee that the buyer is requesting or demanding. That the yard is demanding from the buyer, that you get these kind of these questions.
Well, I think there's something to that, because if you think about what ended up being clauses 3 and 4, which you read out, it doesn't strike me as the type of clause you would draft in one go. you wouldn't start off with clause 3 with this language about, absolutely unconditional guarantee and not merely as surety, and then upon a first written demand, and shall immediately pay, and then go on to have this proviso about, we're introducing all this surety language. If you're wanting to draft this as a demand guarantee, that just wouldn't be there, right? You'd have something that may talk about recredit in the event that the debtor doesn't actually owe liability, or some kind of way of clawing the money back, but it would be clearly a demand guarantee. Likewise, on the other side, if you were drafting this as a surety guarantee, you wouldn't have the demand language in there. So it seems to me unlikely that these two clauses, and indeed the guarantee, was drafted just by one party and put together in a cohesive way. It seems much more likely that this is the product of a back and forth, and in the back and forth, when the buyer's pushing for, or the guarantor's pushing for language which is more along a surety basis, that they're not coming out in the negotiations and saying, hey, hold on, we're going to change it. So we don't want a demand guarantee. We want this to be a surety guarantee. We're going to change this to a surety guarantee. That just doesn't happen. Well, sometimes it might happen, but in commercial negotiations, in my experience, that's rare. What tends to happen is, well, can we chip away a bit at this? Can we, and this is what you're saying, I think, can we soften it somewhat? Can we get some more surety language in there? At least it gives us somewhere to go, to argue this down the track. I think that's what we're looking at here in this guarantee.
Yeah, exactly. You can see the guarantor saying, "Look, I'm happy to pay you if they've just failed to pay. But what if we're not sure whether there's a right to pay or not, or we're not sure whether they're liable to pay." And then you get this wording creeping in about the dispute about arbitration, and then suddenly we're almost 10 years on from the date that this contract was signed. It was September 2011, and now in July 2021 they're arguing before the Court of Appeal about whether or not this, about something which is so central to the nature of the guarantee. Its entire purpose is it a surety guarantee or an on-demand guarantee? And 10 years down the track, that's still an issue. And I think you're right. It's just part of the drafting process that it's a bit of chipping on either side to include some harsher obligations here or soften the obligations there, and it creates a slightly confused picture.
Yeah. What did you make of the definition in the 11th edition of Paget's Law of Banking, contract of surety versus demand guarantee? And I can read this out to you and for our audience. This is kind of one of the textbook definitions on this question of surety versus demand, where an instrument, 1, relates to an underlying transaction between the parties in different jurisdictions. 2, is issued by a bank. Okay, so that goes back to that point about who issues it. 3, contains an undertaking to pay on demand, quote unquote, with or without the words first and or written. And then 4, does not contain clauses excluding or limiting the defences available to a guarantor. It will almost always be construed as a demand guarantee. I bring that up because I'm interested in your thoughts on this, but I do wonder whether that second point, issued by a bank, is where the origin of this argument that the guarantor was running in this case about you need to look at who's issuing it, and that is a relevant consideration. But then also we've got here clearly the on-demand language that's here, and I think we've actually got first and written, even though they say in this definition with or without those 2 words. But we have the on-demand, quote-unquote, language. But then there's this 4th point around, does not contain clauses excluding or limiting the defences available to a guarantor. Is that what this, does the second half, the bottom half of clauses 3 and 4, are those defences of the guarantor that exclude or limit the defences available to the guarantor?
Yeah, I'm slightly confused by what that part 4 means. We're looking at a situation where the guarantee itself does not exclude or limit the defences available to a guarantor. So essentially the guarantor is silent on the defences available to a guarantor, or expressly reserves them, I suppose. It's interesting to me that that's a factor in a guarantee being a demand guarantee. I'd be interested to read a bit more on that, or to understand why that's important. Certainly, I can see the point 3. Does the guarantee contain an undertaking to pay on demand? If it does, then it's likely to be an on-demand guarantee. That I can see that follows. But if the guarantee doesn't exclude the way that the guarantor is able to is able to defend itself from a demand, then it will be construed as a demand guarantee. I'm not certain of the kind of chain of logic that's got Paget's law of banking to that conclusion.
Yeah, I wasn't entirely clear on it either. That's why I thought to ask. Look, I think ultimately the decision rested on 2 decisions, didn't it? On the Wuhan and the Splithoff's case, which both found in relatively similar circumstances that there were demand guarantees. The court didn't spend much time on those cases. What the court did spend time on was saying that the other cases were irrelevant and didn't really need to be dealt with, although out of deference to the guarantor did so. But did you have any points you wanted to touch on Wuhan or Splithoff?
I think that the way that this judgment kind of ties them together, and it sets out a kind of pathway for interpreting guarantees, moving forward from this decision, is the first thing that we have to do is we have to make sure that we're considering the guarantee as a whole. I think that can be a difficult exercise for the reasons that we've mentioned, which is that some clauses the guarantor will have won on, and they'll have chipped away at some of their guarantee obligations. In other clauses, the yard or whoever the beneficiary of the guarantee is will have won, and they'll have increased the guarantee in a few places. So reading it as a whole is often going to give a slightly complex picture. But then you have these, certain words and certain phrases that help to paint a picture of what the nature of the underlying obligation actually is. And we kind of draw those things together in each guarantee that we review to look at whether or not this is payable on demand, or whether it's payable only once you've proven the underlying obligation.
Yeah, I think that's a good place to wrap this one up, Calum. I found this quite an interesting case. Good case to revisit if you ever have a matter where you're looking at, is this guarantee a surety or a demand guarantee? And I say that because it's quite methodical in the way that it does it. It also gets to the heart of what's important here. That's looking at it as a whole. But that said, there's the court still, in coming up with the right decision, has to go to the exact words that are used in this guarantee, construing it as a whole, looking at it in its commercial context. But you still need to look at what's at the heart of the obligation that's being guaranteed here. And that's really what carried the day in this case. And I think what carries the day in these guarantee cases more generally. So thanks for your time, everyone, for listening in. Good times again, Calum. Always a pleasure. And yeah, just to everyone listening in, if you're enjoying this series, we'd really appreciate it if you subscribed and followed us on Spotify and Apple Podcasts. New episodes will be coming into your library on Thursdays. I think this is the second last one before our final podcast of this series, and we'll be taking a very short break of a couple of weeks for August over the court summer vacation break, and then coming back for season 2 shortly thereafter. So listen out for next week's podcast, which will be the last one of this series. And we've got some great ideas and bringing in some new people to kind of spice things up. Calum and I will continue to be the hosts, but we've got some interesting things coming your way in series 2. So look out for next week's episode, and thank you again for your time. Take care.